Boy, you got your own.
5 seconds.
Hi, my name is Dan Fowler. I'm president of the Apartment Owners Association of California. We're one of the largest organized, individually organized groups of apartment owners in the state. And we have one goal that we set for all of our members, and that is everything that we do is dedicated to helping you make and or keep more money than ever before and making your job of providing housing for others easier and more enjoyable. We do this through many different things. We have trade shows, one of the largest trade shows in California that we put on when we can take the masks off and go and communicate with each other again. We have our seminars that we put on, the magazine that comes out every month. You want to be sure to read this. We'll have things in there that you can cut out and send to the governor, send to the mayor of your city, the other politicians in there each month that you might want to do. So you want to get that magazine. Tenant screening, of course. Insurance, when your insurance comes up, you want to be sure to get a quote from us. A RUBS program that you can save money on with that. A brokerage division to help you evaluate your property. Rental payment programs, and on, the benefits of our members that we provide. I want to tell you a story about one of our members that called me this last couple weeks ago and told me his story. Basically, I'm going to change his name, going to change the number of units that he has to protect him. He didn't want his story told, but I'm going to tell you, this has happened before. This is not the only person that I've heard from that similar things have happened to. But John, we'll call him Johnny, 20-unit building up in Oakland, okay? And he had a tenant that moved in. Looked real good. His credit report looked good. His well, you can't get a criminal report up in Oakland anymore now. They outlawed that, and so we can't do that. And so this can happen to you. This can happen to you. When they start outlawing us finding out whether a guy's a criminal or not, we're going to have criminals moving into our buildings. And when this happens, well, this is what can happen to you. He took in this tenant. It wasn't long, a month or so, he did not pay his rent. So this was last year. So he filed for an eviction. The day before the eviction was to go into effect and the sheriff was going to come out and remove the guy, they passed the law and took away the eviction courts. So he was not able to get this criminal out of his building who was causing problems, disturbing all the other tenants in the building. And but because they shut down the eviction courts, he was not able to get rid of this guy. The guy had given him, he found out, a fake ID, had the criminal record, didn't know that because it didn't show. And beside that, Oakland, you can't even get a criminal record up there anymore. The guy started dealing drugs, had a lot of girls coming in and out all the time, guys coming in. So he was dealing in prostitution, he was dealing in drugs. Pretty hard to prove it. When the police come by, of course, everything looks good. Back to court, he lost. He lost in court. He went back to court again because he was disturbing all the other tenants. You ought to be able to get somebody out for that, right? Judge said case dismissed. Didn't get him out after they went back to court again. He thought that, we were supposed to have peace and quiet in the building. All of his tenants moved out. Now, can you imagine having a 20-unit building? You depend upon that. You bought the building, say, 15 years ago. You were getting it paid up. You're building up some equity. And now everybody moves out. You can't afford to make the mortgage payment. You're going to lose your building. Well, back to court a second time, lost again in getting this guy out of the building. So now the guy was basically just saying, I'll do what I want to do, and continued his problem. It spilled over into the neighbor next door. There's an apartment building next door. Some of those people started moving out also. Now, the last that I heard from this person a couple of weeks ago, he was losing his life savings because that was his retirement in that building. Maybe yours too, but this is a danger that we're facing today unless we organize, get together, and do something about this to stop it. The attorney told me again that particular judge that he got never, ever saw a landlord that he liked. never saw a landlord that he liked. We have judges like that are up there. We also have judges that have shut down the eviction courts, and you're going to hear more about that today in the lawsuit that's been filed against that. Folks, we have got to do something to stop this type of thing going on, because it can happen to you any day, any time that you're doing anything. You can get fooled, and one of these guys can move into your building, and these things can happen to you, can happen to me as we go along. And we have to do something to stop these judges, the militant tenant groups that are out there, and also the politicians. The politicians are at the base of this. They're the ones that have caused a housing crisis in the first place by passing the laws that they pass. The lawsuits have been filed against this. You say, well, Dan, what can we do? How can we stop this? Well, there are a couple of ways. One is through lawsuits, and we're going to talk about that today. We have the attorney handling the Pacific Legal Foundation lawsuit that'll be speaking to you, telling you about that lawsuit, and hopefully after they win that one, they'll move on to other lawsuits because of the things that are happening to housing providers today. Block, Jennifer Weir, and many other lawsuits. Up north, there's lawsuits going on to stop these things that the politicians have done and the laws that have been passed. The other way we can do it is at the ballot box. It takes money. At the ballot box, it takes money for lawsuits. And I'm not talking about just millions of dollars. I'm talking about hundreds of millions of dollars to file lawsuits and to beat and win an eviction at the November election coming up. Now, there are two things that they're going after you for. Number one are property taxes. Prop 15, you want to tell all your friends to vote no on that proposition. And even on top of that, Prop 21, which is going to take away, and this is, I'll just say one bad thing, a lot of bad things about it, worse than the statewide rent control that we have. They want to take away, this will take away your right to set your rents when somebody moves out of your building. So they're taking away eviction decontrol. So you will have eviction control if Prop 21 passes. Now, we all want to stop that, don't we? Don't we? Raise your hand. Do you agree with me? You want to stop? Of course you do. How about how badly do you want to stop it? Do you want to stop it to make an investment into it? You know, you buy insurance to protect your building. Today, winning at the ballot box is like buying insurance. You want to protect your building? This is the way to do it, is to make donations. Now, just one project that AOA is working on, and we're going to have several projects that we'll be working on to stop these tenants and politicians at the ballot box. And number one are signs. And you can buy a sign. The signs are going to cost us a lot of money this year. 2 years ago, we put out thousands of signs, and it didn't cost much because we had seminars. All of you came to the seminars. You picked up your signs. This year, we're going to have to mail the signs out to you. So we've got to buy the signs, we've got to package the signs, and we've got to pay a very high amount of postage to get the signs to you. That is going to cost tens of thousands of dollars, hundreds of thousands of dollars, if you want to get the signs out there throughout the state of California. And we need to get thousands of signs on the lawns of individual housing owners and also at apartment buildings to tell people to vote no on Prop 13. And here's an example of the sign that you'll be getting in the mail. If you make a donation, you'll be getting this sign in the mail. The only difference is it won't say Prop 10, it'll say Prop 21. This is one from 2 years ago that we put out on thousands of lawns at that time. And so these will be mailed out. You can imagine packaging these. We've got to package these things to go out to you. And so it'll take about $15 for each one. So if you'd like one sign, anybody who donates for signs, of course, will receive a sign through the mail. $15 for one. You know, there's not a person listening to me right now. You could sponsor at least 10 signs for $150. And many of you everyone should be sponsoring 100 signs out there. Then we could really get them spread out across California to tell people how to vote in November to save housing. As the sign says. You say, well, I don't want to put one up on my sign. It's for to save affordable housing. Now, the tenants want affordable housing too, but that's what we want to save. We want to save affordable housing and make it affordable. And this these laws that they've passed, of course, have caused the price of housing to go sky high. And so we're asking you today to send in a donation to the, you can do two ways. You can send it in to 6445 Sepulveda Boulevard. You see it there on the screen, the address given where you can make your donation, or you can go to the AOA website, aoausa.com, and on that website, underneath the little red buttons, you'll see a big banner to donate to the Political Action Committee. Donate $1,500. Really consider that. Sponsor at least 100 signs. That's not very many signs for you as an individual. That's not much insurance either to buy on your building to help us win this election. We're going to turn it over now to Jeff to introduce our speakers, find out more about the lawsuit that's going on. Pacific Legal Foundation is going to be coming on and tell you about that, bring you up to date. And want to thank all of those of you who have donated. We've been able to send them a very small donation of about $14,000 so far. We would like to donate a lot more to them, but it depends upon you as a housing provider. And we ask you today, join together with us. Join together in this fight. Help us win this battle against these, well, they're not really moral people, are they, when they're trying to take your property away from you? You want to protect your property. So donate today. And I want to thank you very much. I'm going to turn it over to Jeff Fowler now, and he'll be introducing our speaker from Pacific Legal Foundation.
Well, good morning, everybody. Very excited about today's speaker that we have with us. But before I want to introduce him, I just wanted to share some things about AOA and some updates, just so that you're aware of what's happening. With this video, we're going to leave it on the website so you will have access to it. And most of our videos, by the way, we make it free live. And then after that, we put it in the member area. And there's a video tab. You just click on that, and you're able to see those videos at any time. And that's just one of the things that we do at AOA. We also have the advising, and we have local people from San Diego all the way up to Alameda that have offices. We have offices in California, and you just give us a call and we can help you with that landlord tenant question that you might have. And also we do have forms. And just wanted to give you an update. Last week, we had mentioned that we had suggested that you ask if people have paid their rent in full. And so we updated our written criteria list and also the rental application. Those two forms have been updated. So just be aware of that and start using the new ones. Don't use the old ones. And also want to mention the AOA tenant screening. We've been doing it since the 90s. But specifically, we have a new way when you're getting set up on your account. When you log in to your membership, you'll notice that there's a verify ID button. You only need that if you're setting up your account for the first time. And so we've had questions about that. And that's just a feature to make it so that you don't have to submit paperwork when you're setting your account up. It makes it easy to do that. And we have a lot of advertisers in our magazines. They are open for business, or they would have pulled their ad. So please use their services, give them a call. And also we do have specialized apartment insurance just for you. And they do a lot of different things, but really we will take care of you with that. You can call our office and they'll set you up. And also another thing that you get as a member is a free property valuation. You can call our brokers and do that. We have debt reporting, which you can do for those debts that happened before COVID. And so if you have debts to report, we have a service where we will report those to the top 3 credit bureaus, and that'll be on their record. And then also they'll go to collections after 90 days. So anyway, it's a great way to hold people accountable. And just ask that you would think bigger, think of the whole industry. It's not just you that they skipped out on, but if they're held accountable, then the next guy that gets them will know they'll know what they're dealing with before they ever get there. And then also last week, I don't know if you missed it, was Livable, and they offer enterprise level software for smart utility billing. It's an incredible program, incredible people over there. And so we've partnered with them, and we selected them specifically because they can do anything from 2 units on up. And most of them, they can only do it if you have 20 units, whatever, 50 units or more, and that's not the case with them. And we also have Pay Rent, which is a way for your tenants to pay the rent online. And so you can give them a call. And then we also, again, the Political Action Committee, and Dan shared a lot there, and he's been doing a lot. And but it's not just him, it's actually all of us. And what we try to do is empower you and have you get your voice heard. And if you've been silent till now, it's time to not be silent and really get involved. And so we hope that you're able to do that. So our speaker today, really, I wish that Al Leibowitz would be able to introduce him today, because it's really Al and Dan that have played such a major role in bringing this to the attention of Pacific Legal Foundation. And anyway, they are an incredible nonprofit organization, so they do rely on your donations, and their practice focuses on the separation of powers. And anyway, so it's a powerful group, and in fighting for our rights and our freedoms and the way that actually works in America. And so our guy, he's really sharp. He graduated from Stanford Law School. He clerked for a federal judge at the U.S. District Court for the Northern District of California. And it's my pleasure to introduce to you Michael Poon. Oh, and before I introduce him, I forgot to say one thing, and that's for the questions today. You may have landlord-tenant questions, but he is not an eviction attorney. And so that is not his wheelhouse. He will not be able to answer the questions. And even if you ask the questions, I will not ask him. However, there is that blue help button on the right side, bottom right side of your screen. If you click on that, you can put in a question that pertains to this lawsuit. So ask him questions about this lawsuit. Listen to him. And if you have questions, then we'll have question and answer time after this. Thank you. So I'm turning it over to Michael. It's really a pleasure to have you. Thank you, Michael.
Thanks, Jeff, and thanks for having me. It's great to be able to speak about this topic that's affecting so many landlords. Before I begin, I just want to acknowledge the unfairness that a lot of landlords are facing right now. You hear it from great organizations like the AOA, but you really don't hear it enough, I think. It's not a matter of whether you can absorb loss. It's not a matter of whether you're near bankruptcy or you're really struggling because of this coronavirus pandemic. The question is whether we still have property rights in this country and in the state, whether contracts still matter, whether two people can still come together and come to an agreement for mutual gain and follow those terms of the agreement. And that's what's being placed on your backs right now. The idea that the coronavirus pandemic someone needs to bear the cost, and we're just going to put it on landlords. And it's not fair. You know, if the government is going to require that you keep people in your property, they should pay you. There should be some sort of program that makes sure that you are not the one just taking on this burden. You shouldn't have to. But with that said, let's go on to the next slide, and we'll talk about Emergency Rule 1. Emergency Rule 1 is one of the eviction moratoria that is in effect in California right now. And how it works is it tells courts that they're not going to issue summonses anymore. They're not going to issue defaults or default judgments in unlawful detainer actions. This Emergency Rule 1 was issued by the California Judicial Council, which is an agency within the judicial branch of the California state government. And it's responsible for administrative things inside of the judiciary. things like it'll issue rules on things like the format of briefs, minor deadlines, small procedural matters. And what they've done in Emergency Rule 1, of course, is they've taken on a much larger role and said, we're just not going to hear eviction cases anymore. There are two important parts of Emergency Rule 1 to know beyond the fact that it stops courts from hearing unlawful detainer actions. One is that it doesn't have a specified end date. It is pinned to the emergency declaration regarding the coronavirus pandemic. So it sunsets 90 days after the end of the declaration of emergency. And that is, there's no end in sight for that. And two is there is facially a public health and safety exception to Emergency Rule 1. So the idea is if you have some sort of public health and safety problem with a tenant that requires you to evict them, you would be able to do that. But the problem is that there is no particular procedure for how to do this. It's the application of the exception is at the discretion of the court. So there's it's really not a very functional exception in our view. So that's Emergency Rule 1. Get to the next slide. I want to talk a little bit about the relationship between Emergency Rule 1, local eviction moratoria, and the governor's executive orders, because there has been some confusion in this regard about when Emergency Rule 1 ends, when the local moratoria will end. So Emergency Rule 1 is statewide. It applies to all the courts, all the state courts, and it's issued by the Judicial Council, and it ends 90 days after the emergency declaration terminates. Now, that's one eviction moratorium that we have in the state right now. Another layer of tenant protections is the county eviction moratoria. The county eviction moratorias are by county, and those are supported, both the Emergency Rule 1 and the county eviction moratoria are supported by the governor's executive orders. There's one executive order called N3820 or Order 38, which supports Emergency Rule 1. It suspends various statutes so that Emergency Rule 1 can go forward and not be in conflict with the law. That's what it does. And we'll talk a little bit more about that later. But that's Order 38. It doesn't have an end date. All right. And then we have Executive Order N2820 or Order 28. And that originally ended on May 31st, but it's been pushed out several times, and it now ends on September 30th. So if nothing changes between now and September 30th, then the Order 28, the one that supports the county moratoria, will expire. And the county moratoria would then, the idea goes, the county moratoria would then no longer be in effect. They wouldn't be supported by the executive order anymore, and state law would come back into effect with respect to the county moratoria. But because there's no end date for Emergency Rule 1 or the governor's executive order supporting Emergency Rule 1, Emergency Rule 1 would still be in effect even after September 30th, even after the county moratoria go away. And so landlords seeking to evict a tenant really have to overcome both layers. They have to overcome the county moratoria and the statewide Emergency Rule 1. So that's something that is important to keep in mind. If we can get to the next slide, then I'll talk about Christensen versus California Judicial Council, which is our lawsuit against Emergency Rule 1. In this lawsuit, we're representing two landlords. They're both retirees, Peggy Christensen and Peter Martin. Peggy rented to a tenant, and he brought in his girlfriend. he subsequently left the apartment, and she stayed there, and they felt bad for her and just let her stay. But she started damaging the property. She started creating a nuisance. She got lots of complaints from neighbors. And so Peggy tried to evict her, but she wasn't able to because of Emergency Rule 1. Now, Peter Peter owns a 27-space mobile home park, and he had a tenant that seemed to be caught up in drug issues. There was a search warrant served on his home. He had been arrested on drug and firearms charges, and so he tried to evict him for being involved in drug-related activities, and he wasn't able to do that because of Emergency Rule 1. And both of these tenants are not paying rent, so it's really putting Peggy and Peter in a tough spot, like I imagine many of you are in. The suit is currently in Kern County Superior Court, and it makes two major points. One is that Emergency Rule 1 is an exercise of legislative power. It's the idea that the judiciary should not be making policy. It shouldn't be weighing the interests of society and picking winners and losers and saying that we're going to put the burden of the coronavirus pandemic on landlords. That's not something the judiciary gets to do. The second part of it is that the judiciary ignored all of the pre-existing laws that say summonses have to issue at this point, defaults have to issue at this point. It ignored all of the legislature's mandates that control how unlawful detainer actions go. So let me get a little bit into that. So we make three claims that raise these 2 points. The first claim is a separation of powers claim. The California state constitution explicitly divides power amongst the 3 branches of government: legislative, executive, judicial. And it says people who wield a certain kind of power can't wield any of the other 2 kinds of power. So someone in the judiciary, for example, can't exercise legislative or executive power. And that's really what has happened here. When the Judicial Council issued Emergency Rule 1, part of the report that accompanied Emergency Rule 1 said the pre-existing eviction moratoria, the pre-existing help for tenants, it's not enough. We have to step in, and that's something that they're not allowed to do. And again, when the Judicial Council considered amending Emergency Rule 1 to have it sunset in August, they ultimately didn't do that. They pulled back. But at one point, they considered amending Emergency Rule 1 so that it would sunset in August. And when that happened, the Judicial Council explained, the legislature wasn't in session when we issued Emergency Rule 1. Now they are. They weren't there to address this housing issue, so that's why we stepped in. Again, this is just more evidence of the fact that the Judicial Council stepped into the legislature's role. It picked winners and losers. It weighed the interests of society, and it struck a balance. And it's not allowed to do that. Judges, courts are supposed to apply the law, not make the law, and that's what they did here. So that's one. The second claim that we bring is the California state constitution requires that the rules issued by the Judicial Council not be inconsistent with statute. And of course, Emergency Rule 1 is inconsistent with all of the procedural provisions regarding how unlawful detainer actions are carried out. All of the statutory provisions saying summonses issue at this point, defaults issue at this point, default judgments issue at this point. It's inconsistent with all of those, but it's inconsistent with more than that. It's also inconsistent with just your right to have to be able to evict someone, your right to reentry, your right to possess your property. These are all statutory rights that Emergency Rule 1 ignores and is inconsistent with. And so that's the basic claim for the second one. We expect that the government's response would be that Order 38, the executive order supporting Emergency Rule 1, allows the Judicial Council to issue Emergency Rule 1. Now, I want to get a little bit into Order 38 and what it does, because it's pretty important. So Order 38 was issued under the governor's authority under the Emergency Services Act. The Emergency Services Act allows the governor to suspend certain statutes under certain conditions. And so the argument is that Order 38 suspends all of these statutes that Emergency Rule 1 is inconsistent with. And because those statutes are suspended, Emergency Rule 1 isn't actually inconsistent with them. And so Emergency Rule 1 doesn't violate this constitutional provision saying rules issued by the Judicial Council have to be consistent with statute. Now, there are a lot of problems with that. This Emergency Services Act doesn't just let the governor suspend any sort of statute. He has to follow certain procedures. First, he has to declare that statute in question, statute being suspended, is impeding the recovery from the emergency at hand. He didn't do that in Order 38. He did that in various other executive orders relating to other things, but in Order 38, he didn't do that. And so he can't use the Emergency Services Act to suspend those statutes without having made that finding. It's one of those accountability mechanisms one of the very few accountability mechanisms that the legislature created to ensure that emergency powers aren't used just willy-nilly, right? So that's one problem with Order 38. Another problem is that the governor can only suspend certain kinds of statutes under the Emergency Services Act. He can only suspend regulatory statutes, statutes regarding the conduct of state business, and he can only suspend regulations. So those are the three kinds of items that the governor can suspend under the Emergency Services Act. Now, these unlawful detainer provisions are none of those, right? These are really about your ability to vindicate your right to go back into your property. It is not a regulatory statute. It's not something about conduct of state business, and it's not a regulation. So the Emergency Services Act just doesn't let the governor suspend these unlawful detainer statutes. Third, in Order 38, the order that supposedly supports Emergency Rule 1, in that order, the governor only suspended procedural statutes that would get in the way of the Judicial Council rules. That order only suspended procedural statutes. Now, what that means is that Order 38 can't be used to suspend, for example, the statutory provisions saying you have a substantive right to enter your property, to evict someone who isn't carrying out the terms of the lease properly. It doesn't suspend those statutes, and so those statutes are still in force, even if everything about Order 38 was fine, even if it followed the Emergency Services Act to the T. It doesn't suspend those statutes, and so Emergency Rule 1 is still inconsistent with those statutes, and it still violates the California constitutional provision that says rules have to be consistent with statute. That's another problem with it. And one of the very big problems, the fourth really big problem with Order 38 is that it really gives the governor's power, the suspension power, over to the Judicial Council. What Order 38 actually says is if the Judicial Council considers adopting a rule that would be inconsistent with the statute, then I will suspend that rule if it's a procedural statute. I will suspend that. I suspend that rule. And what this really does is it gives the choice of which statutes to suspend to the Judicial Council, right? Because what it means is whatever sorts of rules that the Judicial Council wants to consider, contrary statutes are suspended. It's not the governor saying this statute, this statute, this statute, these are impeding recovery, I'm going to suspend them. And so that's a problem because the governor can't just give his power to another branch of government. The legislature was clear that the governor needs to make this decision, that the governor needs to declare these specific provisions are impeding recovery and need to be suspended. So necessarily, he cannot declare that whatever statutes the Judicial Council thinks are in the way, that those are impeding recovery. And he doesn't even know what statutes they are yet when he signs the executive order. So that's a fourth major problem. And the final problem has to do with Emergency Rule 1's termination date. Emergency Rule 1, by its own terms, ends 90 days after the end of a declaration of emergency. So if the governor were to end the declaration of emergency today, would have 90 days, it would be, I guess it would be October before Emergency Rule 1 expired. And the problem with that is the governor only has suspension powers under the Emergency Services Act when there is a declaration of emergency in effect. So once his declaration of emergency ends, even if everything about Order 38 were kosher, it followed Emergency Services Act, and it encompasses all of these statutes that Emergency Rule 1 conflicts with. Even if all of that were the case, as soon as the emergency declaration ends, all of those statutes come back into effect. The order 38 goes away, the suspension goes away, and at that point, Emergency Rule 1 would conflict with all of these statutes and violate the California constitutional provision that says rules have to be consistent with statute. So those are the five main problems with Order 38. So Order 38 isn't properly issued, doesn't cover any of these statutes, and because of that, the Judicial Council could not have relied on Order 38 in order to issue Emergency Rule 1. And because Order 38 is defective, that means that Emergency Rule 1 is inconsistent with all of the statutes saying unlawful detainer actions have to proceed a certain way. And because of that, it's unconstitutional. So that's the second major claim. The third major claim in Christensen versus California Judicial Council is rules issued by the Judicial Council can't be substantive rules. This, again, comes out of the California Constitution, which recognizes that the Judicial Council, the courts, have to be able to issue rules for how courts conduct themselves. Or minor administrative details that the courts need to deal with. But it recognized that these sorts of rules can't step on the legislature's toes, that they have to be limited to procedural questions, they have to be limited to administrative issues, that the Judicial Council isn't here to make the law. So that provision is in the California state constitution. And clearly, Emergency Rule 1 is not following that, because it's not just a procedural question that Emergency Rule 1 is addressing. Very facially, it is. It's just talking about summonses and defaults and default judgments. But what it's really doing, its effect, is to say you don't really have a right to evict people anymore. That's a substantive determination. And that means it violates this portion of the California state constitution. One more note about Christensen versus California Judicial Council. this suit is one that if we win, if everything goes well, what we ask for in this suit is for the court to order the Judicial Council to revoke Emergency Rule 1. And what that means is that would apply to everyone statewide. So even though we only have Peggy and Peter in the suit, if we win, Emergency Rule 1 would be gone for everyone. That still leaves the local ordinances, the local eviction moratoria that landlords will still have to worry about, but it gets one major barrier out of the way. So that's why we're really focusing on this suit. Let's see. So that is the case in a nutshell. If we get to the next slide, and this is really the end of the presentation, but I wanted to drop a quick note before I wrap up. Landlords are really used to doing things by the book, I think. Everything's very orderly. You have a contract, you follow the contract, you honor your obligations. If something goes wrong, you go to court. I think landlords tend not to kick up a fuss. But this is really the time, like Dan was saying, this is really the time for you to be speaking up. It is really important that you make your voice heard, because it's because landlords often don't speak up as loudly as tenants' rights groups, for example, that they just keep getting burdened with additional regulations, additional sacrifices that they're forced to make for the community. It's the sort of thing where you really need to go to your city council meetings. You need to go to your county supervisors. You need to email the Judicial Council. You need to get in contact with the governor's office. You need to talk to your local media, your local radio stations. You need to get out there, because you're fighting for your lives. You're fighting for your businesses. You're fighting for the idea that two people can still get together and come to an agreement and honor that agreement. These are not things that you should take lying down. You need to get out there and just tell your story. Tell your story about the sorts of problems you're having, the sorts of tenants that you can't evict, and the sort of people you've had to turn away because you're forced to keep these tenants. You just get out there, because it's that important. This is a moment when we're really talking about, as a state, as a country, how society should be structured, and it's not the time to be silent. So that's the end of my presentation, and let's go to Q&A.
All right, thank you so much for sharing that with us. And so there are a few questions here. And the first one is, when did you file the lawsuit, or when was the lawsuit filed?
Sure. The lawsuit was filed in mid-June. We had been looking at this issue for a while before that, but the Judicial Council considered amending the Emergency Rule 1 so that it was sunset in August, and it was ultimately after they decided not to amend the rule so that it was sunset. It was ultimately after that we filed the lawsuit.
Okay. Here's the money question. Do you think you'll win?
I think we have a really good shot. I think the arguments are really strong, and that it's really hard. Honestly, it's really hard to avoid these sorts of conclusions that we're drawing in this lawsuit. The question is what the courts are going to do about it, right? The Judicial Council is part of the judiciary. It could be an awkward situation in that regard, but just on a pure question of law, I think we have the law on our side.
Okay, so if the lawsuit is won, does that put the state on the hook for the rent that was accrued during the unlawful period?
I think another lawsuit would have to answer that question. Certainly, our suit seeks damages for our two clients.
Okay.
That for the damage that result from Emergency Rule 1, but whether all landlords are able to obtain damages for the losses that folks suffered during this period, would have to bring another lawsuit for that.
Okay. And when do you think the judge will rule on this case, win or lose?
If all goes well, if there aren't any procedural hiccups or anything like that, then we could see a ruling as early as September, or a little bit after that. But it really depends on how the procedural questions in the lawsuit proceed, and that's a question mark at this point.
Wow. Okay, and then what would the next step be if you were to win this case?
Well, the next step would be hopefully that the Judicial Council would revoke Emergency Rule 1. The real question, though, is whether the government will appeal, and how long the appeals process takes, and whether the judgment, if we win, whether the judgment in our favor would be in effect during this appeals process. So courts sometimes will let an initial judgment go forward during an appeal, or they might stay it and hold it off until after the appeal is over. So if we win, then the question is whether the government will appeal and whether landlords would be able to get relief from Emergency Rule 1 during the appeal.
Okay. And here's another good question. Are you the only attorney on this case?
Don't worry, I am not the only attorney. We have a full suite a whole team on this case. One of our most senior attorneys is on this case, and we have 3 attorneys on this case in total. So we are fully staffed up.
Okay, great. And we have a question here from Los Altos. Is the governor's eviction moratorium, if it's unconstitutional, can your law firm, Legal Foundation, help all the impacted landlords to file a class lawsuit against the governor?
That's not something that we're looking at right now. Class actions can be pretty tricky, and what Pacific Legal is really focused on is establishing the legal principles that are at play. So what we're really focused on in this lawsuit, for example, is establishing that Emergency Rule 1 is unconstitutional. And the question of a class action is something that would really slow down this sort of suit. Like if we had brought Precision versus California Judicial Council as a class action, we're looking at, if all goes well, we're looking at a judgment in September, and that would really be dragged out if this were a class action. And because Emergency Rule 1 would be revoked for everyone if we are successful in this suit, that's just an additional reason not to go class action at this point. But certainly I know that there are attorneys in the private bar that are working on this issue and are probably looking at class actions as well.
Great. And they're asking, can AOA play a leadership role in uniting landlords to file a lawsuit? And I think we're kind of put our eggs in the basket with what Pacific Legal Foundation is doing, and we're going to push hard here. We have limited resources, so we're really going to focus on the Prop 21 and some of these things that are going to be on the ballot in November. That's where we're going to put the Political Action Committee funds that we do receive. We're going to be putting it towards, we're going to be helping Pacific Legal Foundation, and we're going to be helping with the things on the ballot. And so that's where we're focusing, and strategically that's where we're deciding to put our efforts.
Yes, and I do want to jump in and say AOA has been very helpful in our putting together this lawsuit, and they've been with us just every step of the way, and has been a great help in, for example, identifying landlords who are suffering from this problem, who would want to speak out and stand up the way Peggy and Peter are.
Yeah, awesome. And we love Al Leibowitz so much. He's a member of AOA, and he's really had such a massive part in it. And it just goes to show you, one person, you yourself, whether it's just writing a letter to the governor or whatever you do, you can really make a difference. And I think to remain silent, I want to plead with all of them, remain silent. And this isn't the only issue to remain silent about. There's lots of issues that you could be writing your local and state officials on. And, we celebrate the 4th of July. And part of that is that every single one of us would have freedom of speech and to say things and to speak our mind. And so exercise your freedoms. And that's important.
Absolutely.
Okay. We have one from Citrus Heights. Can this be appealed? Okay, yeah, let me see. I think, yeah, can what you're doing be appealed? And I think you answered that.
Yeah.
Already, so but I'll let you.
This sort of action would be subject to appeal, whoever wins. Yes. Right,
and then if it's appealed, then what would happen after that? When would it go before a judge after that?
After that, that's sort of unknown at this point. It really depends on what state the courts are in at that point and how quickly they're running. And appeals can take a while. That's
great. Okay, and just as we wrap up, I want to thank you so much for being available and putting your heart and your passions into this. It really comes across, and we appreciate your hard work and also your expertise. And is there anything else that you'd like to share with us before we close out?
Yeah. We are a nonprofit foundation.
There we go.
It means we're able to represent people like Peggy and Peter and push these issues forward for all landlords, all property owners, everyone who believes in the idea that you should be able to control your property and enter into contracts. It does mean that we are reliant on donors, and if you are able and would like to contribute to the cause, you can go to pacificlegal.org. That's pacificlegal.org, and you can make a donation there. And if you do, that would be great. And if you don't, that's all right. We understand that it's a tough situation for everyone right now. And you can just get out there, make your voice heard, and talk to your elected representatives, and that is even more important, really, at the end of the day, than what we're doing. So get out there.
Here's one more question that did come in. They still want to use your services, I think. So they're like, okay, if it's not a class action lawsuit, can an individual landlord get help from your firm to file a lawsuit against the governor's eviction moratorium?
We are considering these sorts of actions all the time. If you are in a particular situation where you want to get in touch with Pacific Legal and see if we want to bring a case, you can go to our website at pacificlegal.org and submit a public inquiry, and our attorneys will review the cases and get back to you about whether it's something that we can move forward with or not. So yes.
And do you know of any such kind of lawsuit that's been filed anywhere else in the state?
So a lawsuit against Emergency Rule 1, is that, or because there's again some confusion about the executive orders and which executive orders we're talking about. The governor had previously his own eviction moratorium in addition to the Judicial Council's moratorium and the county moratoria. So that one expired already. But with regard to these two moratoria and the respective executive orders that support these moratoria. Our lawsuit is one way to get at whether his Order 38 is effective. And I know there are several other lawsuits out there from attorneys who are in the private bar challenging these eviction restrictions. They're doing it in a little different way procedurally. It's good to get at it from different angles. So yeah, there are multiple efforts ongoing on this issue.
And I have a question here about the idea of forgiving rent and how that relates to emergency rule number 1.
So emergency rule 1 doesn't have anything to say about whether rent is forgiven, whether the tenants still have to pay rent or anything like that. All it says is courts aren't going to hear unlawful detentions anymore. So the question of whether tenants still have to pay rent, whether there's going to be a rent holiday, whether landlords will be able to collect after this pandemic is over, those are all issues that they're open questions. They're being discussed in the legislature. They're being discussed at the local level with the county supervisors. So those are still open questions.
And here's a really good question, and it's coming from Al. So why did you file this lawsuit in state court instead of federal court?
Sure. I can answer that to some extent. We don't want to divulge too much of our strategy, but one of the reasons is that this is an uncertain time period. It is a crisis. People aren't really sure how we're going to get out of it. A lot of people are in tough situations because of the lockdowns and losing their jobs. And I do want to recognize that a lot of tenants are in a tough situation. You can see where the Judicial Council is coming from in some respect, right? Like it's still not right to put all of this on landlords. It's still not right that your contracts get thrown out the window and you can't get it back into your own property. None of that makes that right. But you can understand what they're doing. And I think in moments like this, when you have a state government responding to a crisis and choosing a certain way to go, federal courts are more reluctant to step in. Federal courts understand that they have a limited role, that there is some sort of comedy, some sort of respect between the federal government and the state governments. And so, if you want to move forward in this sort of delicate issue on a state law basis, we're challenging this under the state constitution. It's really the state courts who are in the best position to be looking at these issues. It is a judgment call. There's certainly something to be said for going to federal court. But that's one of the factors that you want to think about when you're bringing this sort of suit.
Mm-hmm. Here's a really good question, and I think it might actually, unfortunately, there's a probability to it. If you win the lawsuit, what's to stop the supermajority Democrats to legislate the terms of emergency rule number 1?
Sure. Yeah. I mean, I would say there are other constitutional provisions that would say you can't just take people's property and put tenants in them. So there are other things that we can argue. In this suit, we are relying on the separation of powers, and so it would be less of a good fit to object to a legislative action under the terms of our suit. And so there are other constitutional provisions we can think about. But look, at the end of the day, it's a democracy. At the end of the day, the people control what sorts of laws we live under. And so, foundations like PLF and attorneys like myself, we can do some. We can slow down, for example, or slide into just total government ownership of private property. We can do some. But at the end of the day, you've got to get out there. You've got to talk to your neighbors. You've got to talk to your elected representatives. You've got to make your voice heard, because we can't, if everyone in the state wants to go one way, we're not going to be able to stop them. You need to get out there and talk to people. You need to make your voice heard and tell your story and help people understand how unfair this is to you.
Right. It's really interesting. It's almost the danger of democracy. And it's important that we have it, that we have the freedom to vote, but it can be really abused. And so I think they're frustrated and feeling a sense of, at what point is this an unconstitutional taking of our property?
Yeah, well, I would say it already is. The question is whether the courts would agree. And it's the rule of law, and it's the separation of powers, and it's the constitutional rights that we have that are supposed to stop majorities from infringing on individual rights. Right? You wouldn't need rights if everyone agreed on how to act. The point of rights is to stop the government, is to stop majorities from interfering with how you live your life and the way that you contract with other people. But courts enforce rights, and courts are ultimately responsible to, or are appointed at least by governor. All of the people in the government that make rights work they ultimately come from the people. So rights aren't some sort of like gotcha card that you can say, well, I have rights, so you can't do this. You're right in some respect that's the case, but it needs to be carried out by a government that understands the importance of rights. And so just kind of going back to my point before, ultimately it's up to what the people are going to do. And that means it's ultimately up to voters, and it's up to people like you all out there who make their perspectives heard. And whether we still have rights is all a function of that.
Mm-hmm. And this question came up: will it be moot if repealed before the decision?
If it's repealed before the decision, then that I think gets into a question of strategy that I don't want to get into. Certainly, if it's repealed before a decision is reached, then that would be great news, and would be very happy about that. But whether our suit would continue is another issue that I don't want to get into at this point.
Okay. So Kathy, she's asked a couple of questions here. Are they considering the tenants who are basically scamming the system, and landlords, tenants who are not abiding by the rules put forth by Newsom? And so I think she's wondering, is there going to be accountability? I think it's outside of the scope of this lawsuit, but just kind of this whole system. Is there going to be, how do you see accountability coming in? Do you see that happening?
That's a really tough question. It really depends on what the legislature and what local governments do in terms of, there are just so many restrictions coming in, so much legislating happening around these issues, trying to shield tenants from the consequences of their actions. And so I think that's really an open question at this point. And again, I do want to emphasize that this suit isn't about, it's not about, these bad tenants, they're so terrible. Certainly there are troublesome tenants out there, just like there are troublesome landlords out there. And certainly Emergency Rule 1 incentivizes troublesome tenants to be more troublesome. And that is a problem. But it is a tricky situation for a lot of tenants, and we do recognize that. And so the question of accountability for tenants who aren't paying rent, that is really a question at the local and legislative levels, and fortunately that's a question on which, if you go out and make your voice heard, you can be a part of that, of how that resolves. Though of course there are significant opposition forces against you.
Right. And end of the day, hopefully, they don't have till 2034 to repay their rent, or 20.
Yes.
Hopefully that doesn't happen. But the way that it can be done is through reporting debtors to the financial bureaus. We have that debt reporting service, and then hopefully the courts will be working better sometime soon. So
yes.
Without being able to hold people accountable, man, it just makes the darkness grow more and more, and so important to have accountability. Okay, here's a question from Edward. Can the federal executive order overrule the citation?
So I'll understand that question to be whether President Trump can somehow intervene in these problems and get rid of Emergency Rule 1, for example, or help people evict their tenants who aren't abiding by the terms of the lease. The answer is probably not, because we do have a federalist system that divides power between state and federal governments, and rent and tenant and landlord issues are usually the province of state government, and certainly the federal government can't force state courts to hear unlawful detainer actions. That's part of what that's unfortunate in some circumstances, it seems like, but overall is part of what makes our system strong. It means that you can have successful states and states that adopt worse policies. Unfortunately, California seems to be one of those. But it means that you don't have a central government stepping in and overriding state decisions. That's part of the founders' design, and overall, it is a force for good. But in this situation, it does mean that this is a state question that has to be resolved at the state level.
Great. I want to thank our viewers today, that you are showing an interest, that you are investing the time in the situation is really important. And then now you are familiar with the situation. You can get out, you can advocate, you can donate, there's so many things that you can do now. And so thank you for being awesome housing providers. And again, Michael, thank you. And we'll sign off.
All right. Thanks, Jeff. Thanks, everyone.
Thank you.